frequently. And as we are responsible steering committee, we hope to organize the important topics that will be reflect to you as your research and findings. And today we organized the lecture on invention and protection of intellectual property. And I would like to introduce the guest speaker and resource person of this topic. There are no any other expert in the country other than Mrs. Geethanjali Ranawaka, the Director General of National Intellectual Property Office, NIPO. Let me introduce Madam Ranawaka, and she holds the Attorney at Law LLB and Masters of Law degree from University of Colombo. And she has been serving in the Intellectual Property Office for over 27 years in different executive grade positions. And she was appointed as the Director General in 2012. And she has presented papers in various IP forums in Singapore, India, Bangladesh, Thailand, Republic of Korea, and Bhutan, and also in many forums at various institutes and organizations in Sri Lanka. She has organized over 22 seminars and workshops on IP in Sri Lanka since taking over as a DG in the collaborative work with WIPO, World Intellectual Property Organizations, and the United States Commercial Law Development Program and United States Patent and Trademark Office. And she has been the member of the Council of University of Moratuwa from 2015 to 2019 and was a member of many committees in various ministries and departments. And currently she is serving as a member of Made in Sri Lanka committee under the Ministry of Industry and National Innovation Agency Council, functioning at the Ministry of Skill Development and Innovation. She also visiting guest lecture in various institutes and universities. So, Madam Geethanjali Ranawaka, I think over to you. I think you already shared the screen. Over to you, and please let me tell the participants. So, any question regarding the talk, you could inbox or chat box the questions, and we will take time after the meeting discussion finish over the presentation that Madam is doing. So, any disturbance will not be allowed. You better to keep mute your microphones and the video. Thank you. Over to you, ma'am.
Thank you, Dr. Kalpa, and thanks again also for your kind words, actually. And good afternoon, everyone, and thank you, Aztec and all the members there for inviting me for this guest lecture, and for these young inventors and also the stakeholder groups in this area will really need the subject of intellectual property for their work, for their research work, and to see the result of it. So therefore, it's I think it's timely for selecting this topic, and also I'm happy to give information on this area because we are the department. We are the only organization in Sri Lanka which looks after the rights of intellectual property rights, actually, and which means the rights belonging to creators. So this is how we should be explaining that. So when our human beings are creating new things using their creativity, human brain and ability, they become new things. And also in the area of scientific fields, it becomes an invention. And in other areas like business, commerce, we name it as trademarks for business, and designs for various items in the market. So, and also musical work and songs and books, they are all coming under copyright, and all these are intellectual property. And as I move on with the presentation, you will see the difference and also the importance of each and every item. Ours is a government department functioning under the Ministry of Trade, and then you will see here our address. For the last 20 odd years, we have been uh, living here, basically, on uh, another register of companies building property, and currently we are looking for a permanent place to relocate and develop, because we'll be able to develop it in a modern way when we get our permanent location. So that is also in our agenda right now, and we are working for that. For the moment, please remember the address and the details, email addresses, and our website is here, given here. You can download a lot of information through this website. And if you have any difficulty, please call us and get more information regarding intellectual property and the procedures that we follow here. And as you are aware, if I'm not audible enough, Dr. Kalpa, let me know, please, because I don't know whether my mic is working well. From here, I can't say.
Enough, ma'am. Yes,
Right,
we can
okay.
hear you. Yes. Enough.
Okay,
Thank
right, thanks. Then, as you are aware, Universal Declaration of Human Rights, Article 27 declares that creators of new work have the right to benefit from protection of moral and material interests resulting from such authorship, which means universally this is an accepted norm that whatever you invent, a novel thing, needs to be protected, and all governments are bound by this to give some protection so that the inventor, the creator, will get encouraged, so that he will be getting involved in making more and more. This is how it happened in the USA in the last few centuries. When they started with the telephone, Alexander Graham Bell, with the telephone, he proceeded from there because he got the first patent for the telephone, and thereafter it evolved, as you know, up to the current most modern iPhones and other all smartphones. And as you are aware, how Apple and Samsung are earning a lot of money out of those inventions, uh, and also how it contributed the economies well. You are aware. So this is
Mrs.
how
Ranavaka,
USA
can you
developed.
just Mrs. Ranavaka, can you just put that slide mode? That presentation is in the. I think it should be slide presentation mode, right? Okay, thank you. Thank you.
Slide. Is it
Okay.
slideshow
Okay.
that you?
Yeah, that you can click it. Yes.
Slideshow. Is it?
Yes. Okay. Go ahead. Yes.
Okay.
Right.
Now
Right.
okay.
Thank you.
Right.
Now okay.
Right.
Thank you. Yes.
Sorry about it. Thank you. So I think you heard what I said about how the other countries developed into this level, uh, simply using the technology in the phones, right? Only the phone that I took as an example, the Apple, Samsung, how they developed, and how Korea, South Korea, and USA developed to this level. You are aware. So we should remember how important and how vital it is for intellectual property for a country, so that it contributes back to the economy of the country. So from this definition of we have gone forward, almost all the countries in the world, to generate, to create, to give some kind of protection within their own territories, countries, like intellectual property law. So this is how all these countries, starting from UK, USA, Japan, uh, developed their uh, intellectual property laws, and we also developed our laws. Uh, Around 1979 only, we developed our own law with the support of the World Intellectual Property Organization. And then we went ahead from there by introducing the new law of 1979 Code of Intellectual Property Act, and thereafter to the 2003 Intellectual Property Act number 36. So these are the two laws, our own laws. Before that, when we were under a British colony, we were following the British English laws. So therefore, you need to remember from 79 onwards only we have started to introduce our own uh, IP laws. So in this presentation, I'll be moving a little faster in the areas of trademarks, designs, and copyrights because your main objective is to learn more about patents and how to protect your invention. So therefore, because it's limited, the time is limited within 1 hour. It's very difficult to explain all these areas. So I'll be moving faster in some of the slides. And if you really need to get to know more information, just point out maybe later the areas that you want to elaborate more. So these are the this is the lineup here. First, I'll be explaining about what areas coming under IP and what are trademarks, what are patents, what are designs, and then copyright. So then let me see what is intellectual property here. Intellectual property refers to creations of the human mind, whatever that you create using your ability. And then such creations include inventions, literary and artistic work, symbols, logos, names, images, designs, and devices which are used in commercial activities. So here the inventions mean the novel invention that you do in technology where you can get, for which you can get a patent right. So this is how inventions are categorized here as intellectual property. And literary and artistic work means that whatever you write, create in a musical work, in a form of a book, in a form of a stage play, drama, music, all these are literary and artistic work. And even computer programs. You have to remember computer programs are protected under literary and artistic work because you cannot get patents for computer programs. Then symbols, logos, names are coming under trademarks where you have to identify, you have to differentiate your uh, products in the market from a certain symbol or a logo. So that is called trademarks, and they are used in the commercial field. So therefore, these are called IP, and IP is an intangible personal property owned by you, owned by the creator, and same as other property, you need to extend your exercise your rights to protect it. That is, the responsibility to protect the intellectual property lies on the owner or the creator of the intellectual property. So therefore, it is up to you to take action, and no other person will come and protect it for you if at the moment it is violated. So this is why our office, the task or the mandate of our office is to administer and control. That is, when you file a trademark application, patent application, we have a look at it, and then we grant the patent. And thereafter, it is up to you to do things that you can get protection from violation. And also, when you are trading, when you are commercializing it, you need to uh, see whether third parties are misusing it. So these things are your rights, your responsibility. Uh, so these are the two main areas under intellectual property. This bundle of rights, intangible property, falls into two categories: industrial property and also copyright. Industrial property is that what are called trademarks, patents, designs. So I explained here earlier. And copyrights means the literary and artistic work that I explained earlier. These are the two different categories and two main categories under which uh, the IP which I explained are falling. So let's see the area, specific areas is the traditional way of explaining trade or service marks, patents, designs, all are universally accepted norms. Uh, these terms, same terms are used internationally also. Copyrights and related rights are the rights of literary and artistic work, and also related rights means rights of performers and musicians, which I will explain later uh, briefly. Uh, Let me, before I go into inventions, let me explain what trade or service marks are. Uh, Suppose you want to do a business, a small time business, a medium, small and medium enterprise you may create to sell some product or do some service, like sell a product means say tea, right? You want to sell a pack of tea. You want to sell a kind of a paint, paint that you create, you invented, or maybe somebody created that paint product for you, and you want to sell it. You want to distribute it. So you will be looking for a way to enter the market, right? You can't enter the market with just the product hanging onto your hand and go and keep it on a shelf of a shop. No, no one will accept. No one will be bothered to look at your product. So what you should do is you have to identify with a certain exclusive, unique uh, uh, mark that will identify your product in the market. So therefore, so for your mark to get identified in the market and to go for purchasing by a consumer, you need to have a certain unique name or a slogan or a word identifying your product. So this is why we say a trade or a service mark is defined as any visible sign serving to distinguish the goods of one enterprise or services of one enterprise from those of another enterprise. So goods and services both have the same similar way of acceptability here in terms of law. So therefore, as I said, if you want to sell a product like paint or a pack of tea on your own, and you have to identify a trademark for that. So you look for a particular mark which will identify your product in the market. So these are some examples from the international market, international systems which are registered in Sri Lanka as well, for you to see how far they have gone in this area, because just because of this brand names. We call them brand names. We call them trademarks because when the legality comes, it's called trademarks. But in your normal parlance, you mention them as brand name. So Puma, Nike are well known among youngsters, especially for shoes, bags, sports products, and all that. So when you want to when you want to buy a certain quality product, sometimes you go for these brands. Pretty expensive, but still sometimes duration is good, right? Long durable ones. So therefore, some people go for these brands. Otherwise, you can also, according to your finances, you can see the locally also there are very good brands. DSI in this area, say bags and shoes, uh, DSI, DI, um, and also Bata. Bata is an international one, of course, with a local collaboration. Bata and various brand names, but the prices are a bit lower than this. So therefore, you can go for those brands. Same way, if you are starting your own business, you need to identify a certain brand name so that you can enter the market, so that your product will be identified, distinguished from another person's product in the market. So this is why even these competitors, Puma, Nike, Adidas, all these people are in the market without a problem, even in a market like ours, a smaller market, not like India or any other China, but a smaller population, but still they are also having a competitive market here because people do want to buy a good product, even paying a high price. So these are all, I think, the young generation will love to drink Coca-Cola, but people say it's not good to drink Coca-Cola, but we like to drink Coke, Coke, right? When you're tired, so you select from this brand name. So these are the exclusive ones that they have registered the brand name, the trademark. No one else is allowed to even touch this letter C. The way it is presented is a unique way, and even the letter C in this manner is not allowed for anybody to use, even for any other product. The moment they see this, they file action against parties who are trying to take even a letter from this uh, presentation, right? These are all called um, trade dress, right? Composite marks, because these are with along with the bottle they have registered this mark, the shape of the bottle, and the color combination. All these are unique marks. So that then this is clear to you how you should go ahead with a business by selecting a unique trademark. Say if you are even uh, say if you are an inventor, you are inventing something new, still you need to enter the market. So this is why I said the trademarks are important, because to enter the market with that product, you need to identify your product with a brand name, with a trademark, so that people will start buying your product from that using that name. So it will be, you can even create a company or you can even trade individually. So these are important points that you need to remember if you are in a business, if you are in a research and development area. These are all useful, because this bundle of rights are very useful for a person to move forward in their lives, in their professions, right? So since patent is the area where you are giving uh, main focus here, I will move forward with the inventions. Uh, you look at the definition, an idea of an inventor which permits in practice the solution to a specific problem in the by way of sections, so that we are unable to deviate from this. And if someone has invented something, we have to go through the sections of the act and decide whether this applicant, this inventor, has fulfilled this criteria. So these are very important points which need to be remembered, because you can't just invent or create something and file an application and ask us to grant a patent. This is unfair, because we have to look at our uh, Intellectual Property Act, because if you want to see the act yourself, here this is the act. So this is very important in deciding to grant trademark, patent, design, uh, because this is the only area that we are concerned, whether these are coming under these provisions, these inventions or trademarks or designs or copyright. So the invention has to be a solution to a specific problem in the field of technology. So you would see now how you would describe it as a solution. Now, for example, when uh, Graham Bell invented the telephone, the first ever one, it was a huge one, like just maybe it has to be kept on a huge table. And then from Graham Bell's that first phone came into a phone where you have two pieces. Like I think you might remember, if you can go back and see old days films, the mouthpiece and the uh, earpiece are two different pieces, right? You have to hold like this to call. Okay, then like that there came the uh, phone. You have to dial. I don't know whether the youngsters have seen that. During our young days, we used to dial. It takes a long time to dial the number, because you have to use the whole system to dial a number. Then thereafter it came the digital one and the touch phone system, and all these are solutions to technical problems in the field, because you need to work fast, you need to uh, uh, compete with the global globalized trade, commerce and all that. So to move in fast to some area, so to talk to somebody, to send a message, these things are very useful. So therefore someone that those inventors came into the current system, created the current system of codeless systems, wireless systems, touch systems, so that they became, everybody accepted them as solutions to specific problems in the field of technology. So this is one simple example that I gave you to remember why all ideas of an inventor will not be given a patent here in this office as a patentable invention. So an invention may be or may relate to a product or a process. That again you have to remember. The, the telephone is a product, but when you are considering a process, say a vaccine or pharmaceutical, they are all, you are giving a patent to the process, right? Now see, now current problem is a COVID issue. We all are facing a COVID issue, and see the number of vaccines coming out from AstraZeneca, Oxford AstraZeneca, and then Pfizer, and the Chinese companies all are coming up with various solutions. They are the solutions to the current specific problem in the field of technology, because we need some solution to this COVID problem. And if we don't have this solution, what will happen? Everybody will die of this, if because of this uh, corona situation, COVID situation. If someone cannot stand this, cannot fight against the virus, uh, result will be the death, right? So the solution is coming up, and so this is for the benefit of the society. So this is why patenting is very important, especially this subject is very important in the current scenario. So I think it's clear to you. Now see how protection is granted. You create the invention, we grant the protection by way of this patent certificate. We grant this patent certificate, and when we are granting the patent certificate, we attach all the patent documents to the patent certificate, so that you get a nice set of documents to show the world that you are the owner of this patent, right? So under the provisions of the Intellectual Property Act and the regulations only, we are granting that patent to the inventor. Uh, so here uh, you have to understand what a patent is. Uh, the state grants the inventor or the assignee. Assignee means sometimes the inventor will do the work, do the inventions underneath as a groundwork, or sometimes nobody knows there's an inventor, and he will assign the whole thing to another party. Then he becomes the new party becomes the inventor, right? So then uh, uh, the state grants the inventor or the assignee by means of a patent the right to exclude others from making, using, and selling the qualified invention for a period of 20 years from the date of application for the patent. So that you need to remember, once the patent is granted, from the date of application, it's valid for 20 years. This is why even if we grant a patent a little late, uh, from the date of application, the patent is valid. So therefore, you don't need to worry. Once you make the application, uh, your rights are well looked after here by this office, and you can start, manufacturing or trading while the patent is pending, right? But somehow we need to see whether it is a patentable one, and if the patent can be granted to that invention, right? So in some countries, uh, this delaying of patent grant is encouraged, because sometimes after filing the first patent application, some inventors go on doing more research, right? When they are doing more research on the particular patent, particular invention, they come out with a better product, better invention than the one that they have applied. So therefore, they will file the improved one and proceed with the application. Uh, and first, because of the first application, his rights are established here at the patent office. So therefore, sometimes uh, the delays are also uh, necessary to improve or develop certain inventions. So in our case, sometimes when we take about 2 to 3 years to grant a patent due to certain physical, human resources issues here. We have a few number of examiners to do patent examination, but still you should remember, even after 4 or 5 years, when we are granting the patent, sometimes it's maybe too little too late, but still, once the patent is granted, it's valid, it's backdated, effective from the date of application, and applicant applicant's rights are protected from that day onward. So the owner of the patent can use, sell, license the patent technology and derive financial benefits out of it. So that is very clear to you what it is. And why are we granting patents? Patent protect inventions and ensure the inventors the benefits resulting from the inventions, thereby providing incentives for creativity. So this is why we say inventors should be encouraged, and this is how people like Thomas Alva Edison, the inventor of the light bulb, that foundation, that fund is still functioning in USA, because they every day, every moment, they are creating inventions, and they are given incentives, because the patent, once the patent is granted, they get a royalty out of it, and they use those funds for more and more research and development. This is why uh, the patents are very valuable for an inventor, and it's an encouragement to uh, proceed with more and more uh, research and development. So encouraging further inventions and promoting investment. So once you invent, what happens? People come up, new people, new commercial entities will come out to promote, to take over your product, and then uh, commercialize, which means you are getting some money out of it, and also the country will get some money out of it. And also, if you are in the export market, the country will earn an export income as well. This is how South Korea came to this level within the last 15 years, because of the invention that they did, especially the Samsung and all the other products, electrical products, electronic products invented in that country. They went ahead with their research and development and came out with such useful inventions. And it's why it's contributing economic and technological development, and also patent information, that is granted patents, pending patents, all these are useful information for the researchers and inventors to carry out their research and development activities, and information about new technologies, because they need not do they need not do research again and again, because if already research has been done, that result will come out as a patent. Therefore, they can avoid that and engage in a different kind of research activity. So therefore, repetition, duplicating is not encouraged, it's discouraged, because if you are logging into to get the patent information, you will see it need not be researched, because if even if you file an application, patent application, you will not be able to uh, earn or get a patent for that. So this needs to be remembered, and following are not patentable. There's a specific section 62.3, discoveries, scientific theories and mathematical methods, living organisms, schemes, rules, methods for doing business, methods for the treatment of the human or animal body by surgery or therapy, uh, an invention which is useful in the utilization of special nuclear material or atomic energy in an atomic weapon. These are all specifically prohibited to give grant patents. So therefore, we explain to applicants that these things cannot be patented. Now, methods for doing business is another area where we have issues, because people uh, come out with various concepts, business methods. Uh, then they come and try to patent them, but we are unable to grant a patent because this is not allowed under patent system. Even discoveries, if you come across something in the nature, it's a discovery. Not that you have invented it. It's a discovery. So you bring it, maybe you publish it, but you won't get a patent, but you will be remembered as a person who discovered this. Okay, right. Scientific theories are also same, and mathematical methods, right? Now, supposing mathematical method that you use to mark say, for example, we can take the Z score system for A levels. There's a Z score system, and most people say that it's a very good system. I don't know, but the person who invented that mathematical method cannot ask for a patent, right? Because it's just a mathematical method. Though it is a new method, it is just a mathematical method which cannot be filed as a patent application. So that you need to remember. An invention is patentable if it is new, involves an inventive step, and industrially applicable. These three criteria need to be fulfilled if you are to get a patent for an invention. So new means not known in the body of existing knowledge, means not only in the Sri Lankan system, but also the international databases, right? This is why some of the patent applications get rejected, and people are frustrated, unhappy, because some of the international uh, international invented uh, patents are also copied, and part of them are given here. So that you need to remember, not known in the body of existing knowledge, right? And involves an inventive step means the development or improvement is not obvious to a person of average skill in the particular field. Like, from where you are, from your patent, from your invention, you need to show how different it is from another existing one, right? So when you create that part, it becomes an inventive step, right? Now, supposing the vaccines that they have invented right now for COVID-19, uh, then if they are to register the patent, they need to show what inventive step in that vaccine uh, against all the others, right? So that inventive step is important, because of that step only that vaccine will work against that virus. Okay, which is the difference between that and the others by way of this inventive step we are explaining. It's a bit complicated thing which cannot be just gathered from this presentation, but when we are considering an application, we look at this, right? And also industrial applicability means functional and operative. Just imagination cannot be an industrially applicable thing, right? Now somebody can say, uh, the sea waves, it's always happening, right? Into the continuous thing. And using that, you can do this and that and that. So how are you going to explain? How are you going to explain that um, function without practically doing it, right? So you need to be able to uh, show us by way of documents how that sea waves will function in coming out with that invention, right? That that power, right? That power may be generating from the sea waves is doing number one, number two, like that. You have to explain. So if you're not explaining, you cannot use it as an industrial applicable product. So means you are failing in your patent. You will not be able to get the patent for that. Now see, an invention is new if it is not anticipated by the prior art, right? So we look at the prior art. So you can read this. Everything disclosed to the public anywhere in the world by written publication, oral disclosure, use or in any other way prior to the filing or where appropriate prior to date of the patent application claiming the invention, right? That is when before the patent application is filed here in Sri Lanka, sometimes there is a priority date for them, for some applicants, which they have filed, for which they have filed in other countries, right? So that's a priority date. From that day, from uh, before even that, before that date also, we'll have to look at the system and see whether there are similar inventions published or given by oral disclosure. This is why we say for university students not to publish their um, not to publish their inventions, the research articles or any work without uh, before filing a patent application. So it's a difficult task maybe to file a patent application first because it takes time. But still, it is advisable not to reveal, not to publish whatever the research work without uh, looking for the first protection, right? So this is if you publish it, and if it is in the internet, and when we are doing a search for that particular invention, we will see those publications against your application. So you should be able to prove that it is your same invention that you have published. But still, if it has expired 1 year before, if you have done that, then you will not be able to get that patent. So this is clearly in our section, uh, our act. Therefore, we always advise applicants not to publish before filing the application uh, in the patent office, right? So above disclosure is disregarded if such disclosure occurred with 1 year preceding the date of the patent application. That is why I said 1 year. And if such disclosure or in consequence of acts committed by the applicant or his predecessor in title, and if such disclosure occurred within 6 months preceding the date of patent application, and if such disclosure was by reason or in consequence of any abuse of the rights of the applicant or his predecessor in title. From third party, if someone has abused that work, then only it will be disclosed to the public. So that way, if it has come out, the applicant should be able to prove that disclosure was happening due to an abuse of the rights of the applicant or the predecessor. That is, applicant's predecessor means sometimes it can be a previous inventor. Otherwise, he has not done anything wrong in that act of disclosure, right? So that way, if we come out with this information, they will have to give us reasons uh, uh, why it is available in the prior art uh, against this application, right? Then try to patent shall belong to the inventor, and inventor means the applicant, um, the inventor can be the applicant as well, because sometimes inventor wants to get the patent application registered uh, in his name, or sometimes inventor is a research arm of the company he is working, or if the university he is teaching, lecturing, or he's a student in the university, so he may not be the real applicant here. He need not be the real applicant. He can be the inventor who is handling the research, but right to the patent will go to the company, university, or the institute that the researcher is working, right? So therefore, you need to remember how the application should be filed. Right to a patent shall belong to the inventor, of course, yes. If not, two or more persons, if there are two or more persons jointly, then right goes to both of them equal rights jointly. And if the person whose application has the earliest filing date, or if priority is claimed, the earliest validly claimed priority date shall have the right to a patent. So there are two patent applications for the same invention, then the priority goes to the first one who came here first, right? For an invention made in the performance of a contract of employment or in the execution of such work shall be deemed to accrue to the employer. That is why I said if you are commissioned or allowed funds to engage in research work, research and development work, you may not be the correct right person to get the patent, right? So then these things you need to remember when you are making a patent application uh, to identify who will be the uh, correct applicant or the inventor, and if there's a group, how the group can be identified as applicants. Like that, there are so many things you need to decide before filing an application. So this is why when you're filing an application here in Sri Lanka, we take sometimes a long time to resolve issues like this, because these are all informal issues, like not the formally what we need, but there are problems sometimes which we need to clear before proceeding to grant the patent, right? So these things have to be cleared by talking to our officers here before you file an application. So you can get more information also via our website. So this is the process of granting a patent application, a bit complicated. You will see filing application, then formality. We check formality means applicant's details, like what I said, and we need to see whether application contains description, claims, abstract, drawings, the details. And then after formality, if we see any issues, then we inform to do corrections. And sometimes these corrections will never come here, and they remember sometime later after 1 year, then they run and come. Then only they start working on it. Then we get blamed for delays sometime because we have informed them, but they have never come back here. So these things you need to remember. If you start the process of filing an application, you need to go up to the end by responding to our queries, right? Then after formality, applications, there is a system called international search report, and without international search report, some applicants file with a search report, uh, and some are without a search report. Then we need to do a substantive examination, for which we are charging extra fee, and thereafter, uh, if the examination is clear, like novelty, inventive step, industrial applicability fulfilled, we grant the patent, right? Then uh, then uh, before granting the patent, we need to publish it in the government gazette and leave it for 3 months, uh, inviting people to file objections, if any, right? This is a must because it is given in the act that you need to give keep it open for 3 months for people to see in the gazette and file any objections against that. because sometimes this invention may not be his own invention. He may have copied, right? So the true owner can come out and file an action. Before filing action means uh, before granting the patent during this period, they can file an objection, but not to our office, but to courts, right? So in this situation, we will get involved in the matter because when it is a pending patent, we become a party to the matter, and we will be submitting our details, information, evidence, and everything to courts through the Department of Attorney General. Now, see, we allow for amendments if there's any error. We don't just refuse and keep. We allow for amendments and we give time also. Sometimes if there are restricted time periods, but still we are really open on that. Sometimes even after 2-3 years of silence, we have opened up and start working on patents because inventions are important to us to develop the country. So therefore, we don't follow that kind of hard and fast rules here in regard to opening up of applications. We try somehow to grant it if it is a if it has fulfilled the patentability criteria like here, right? So therefore, this is the process. And I told you about the formality examination. We check whether information about the applicant, inventor, the fees, whether if it's filed through an agent, third party, the power of attorney, and if it's if it is not the inventor who is filing the application, the letters from the inventor to say that they are the inventors, but applicant is a third party, right? Uh, if a priority is claimed from an international application, then they can claim that here. Uh, and also international search report with the report or without the report, right? This is the application form. It's in the website. You can download. Uh, Certain parts are actually required only for international applicants. Uh, Only for local applicants, there are a few cages need to be filled. But this looks a bit complicated, but we cannot differentiate from the local and the international because we are bound by the international obligations to give the same treatment to local applicants as well as international applicants. So therefore, the same application needs to be given to everybody so that anyone can use the same application to file a local or an international application. So these things need to be filled up, the documents and all that. And see the fee structure here. Students, individual person, and any other company, university, institute. Sorry. If for the search fee, actually almost all are um, filing applications without the international type search report. So therefore, a search fee is involved always. This is very rare. Then 2,300 is charged from a student. 4,025. This is the full amount that I'm saying. Those days, you should file. You should pay VAT also. Now this time from 19 onwards, 2019 onwards, VAT is not a requirement here. So therefore, only the application fee. Individual, these are others, university companies and all that. 8,000 per application up to the registration. And if it is refused even, you cannot claim as a refund, but that particular amount has to be paid. But in Sri Lanka, this is about 8,000, but in almost all other countries, it's about 4 times or 5 times more to get a patent because it's a very valuable document, the patent protection. So therefore, this is how we give time to correct, but not 3 months. Sometimes we have given even 3 years to correct formal defects. So therefore, we don't follow those regulations, provisions in the Act, uh, because we have been liberal in that sense. We look at the documents and see whether non-patentable items have been included. If not, we look at the uh, uh, title. Title should be very clear and indicative of the new product or the process, right? Then now, if it's a pharmaceutical, you have to clearly mention what for what kind of illness that pharmaceutical is created, invented, and that title clearly should be given in here. And when we are doing the substantive examination, these three areas are looked at, and we looked at the abstract, that is drawings and all that, description, how you have described the invention on your own. You can do. You don't have to hire people. If you are the inventor, you are the best person to draft a patent application. But only thing is, you need to give us clear and very clear claims stating what you are really claiming in that, right? Because the claims are very important, because looking at the claims only we can decide what kind of invention you are trying to protect here. Because if not, you will be um, going into the areas of another patent if you do not demarcate your limits, your territory by way of claims. This is why claims are very important in a patent application. So these are all details actually about the patent application. And then description needs to be given here. And claims are important because the rights of the patentee are defined according to the claims. Generally, content of the claim should be confined to those features which are necessary to explain the inventive concept. There can be many claims as well as subsidiary claims, right? In precise, exact words, number the claimed features. So we do allow amendments, then we publish it in the Gazette. Then I told you, if someone third party is objecting, they can go to courts within the 3 months from the publication date. And if there is no objection, then we grant the patent document. Once it's granted, valid for 20 years, then see, let's see, yeah, I think it's 3 o'clock. We have to move fast, I think. 20 years. Here, how to renew? After 2 years from the date of grant, patent should be renewed annually, right? Because you are given 2 years to do your research and commercializing activities, and then only we ask for a renewal fee. If you are successful, then you are rich because of the patent that you have got, and you can pay the renewal fee to the intellectual property office annually and maintain it for another 18 years, right? So this completion of 20 years means during the period you are supposed to earn money, right? Then see, this is how it is done. Renewal is annually. After 2 years you have to do. Then rights of the patent holder, do anything to the patent, assign, conclude license contracts. You will see, now see, when a vehicle is produced in another country, say Japan, Japanese vehicles sometimes are manufactured in other countries, right? Not only in Japan. So under license, the car is manufactured in Malaysia, Indonesia, Thailand, in those countries, and we get the licensed product to other countries. So in Sri Lanka, we see mostly the products or vehicles manufactured in Asian region countries. So you will see the Samsung phone. Sometimes it's made in Vietnam, right? So Korea has a license understanding with the Vietnamese companies, so that under license contract they manufacture the product. So these are things that you can do with the patent, and without the consent of the owner of the patent, nothing can be done. So this is An example about granted patent. Uh, Title of the invention you see, multifunctional oral cavity mouth gag. This is used for when you are treating an animal. It's difficult to hold his mouth, open his mouth and keep. Even then, it can be used on an elephant. This is a doctor. This doctor has invented this product because his experience. By his experience, he has seen the problems that he encounter when treating animals because they don't keep the mouth open easily, and it's a risk to the doctor and also the person who is holding the animal. So it is a very good invention. He applied in 2019 and he completed all the documents, and we were able to grant the patent in 2020 December. So this is see very during a very short period we were able to grant his patent. So because he has given a clear description here, and this is when we uh, uh, searched prior art, we saw it's totally different from whatever the mouth gags that are available in the market in the international arena on the patent system. So it's a mechanical thing actually. So we have granted this patent to him. Now see, this is another one granted patent. Until unless it is a granted patent, we are not supposed to show like this in a public forum. So this is a granted patent. We granted it in 2017. A method of isolating anionic acid from solar anionic acid from the fungus, its compositions and its antibacterial activity against pathogenic bacteria. Its applicant is University of Colombo. There are inventors. You can see about 5 inventors and invention in brief. The details are given here. So this is how we have granted it for the claims that they have drawn. You can see all these things from our system if you come here. Uh, so this is another patent granted in USA to a Sri Lankan. Uh, Title of the invention, fiber block planting system. These are a few examples actually which I am showing you. Name is B. Lanka Shanta. Uh, so this is the international publication of the US patent. All these details, bibliographic data and all the names, company names, details, drawings, everything is given here in one single page. And thereafter only they give a comprehensive detailed document. This is a published document, right? See the claims. There are 15 claims, and claim 1 is clearly explaining here about the invention that he has invented. So this is a clear example about the claims actually, how to draw. So this is going to be the end of patent presentation, patent area. So these details are given in our website and all that you can download. Our act and regulations, information about IP, registration processes, fee structure, instructions, everything uh, have, we have given there. So the second area is, third area is industrial design. Just you need to remember, no one can get a patent for an industrial design type device because we are granting industrial designs only to the ornamental aspect of an article, right? Outside appearance only we have a look. Even by way of a photograph, you can file an industrial design application. It need not have a functional aspect. It is only the designer ornamental aspect only we look at. Then the three-dimensional shape uh, of the product or the two-dimensional patterns, right? So outside appearance, now here in this uh, jewelry, the ring, the presentation, outside the manner of manufacturing, the presentation only we look at. And if it's a novel thing, the way of presentation, the drawing, we will grant the design to the applicant. So once the design is granted, it's valid for 15 years and renewable only every 5 years up to the 15 year, and thereafter it lapses. The patent lapses after 20 years, this lapses after 15 years, but renewable only after every 5 years, whereas patents every year after the first 2 years need to be renewed. Now, these are some of the examples under industrial designs. Uh, Everything around us are industrial design. Even the shape of a vehicle, certain brands have special shapes. So these are all exclusively an industrial design, and that also earns a lot of money for companies when they create it. These are copyrights, and I think Dr. Kalpa, we don't have much time now. Uh, we will restrict now. The copyrights are the areas where
Okay,
you get
you can
protection
take
for, say, 10 minutes. Yeah.
Yeah, a couple of minutes, ma'am.
Um,
Yes, yeah, we have some questions.
a
Also,
couple of, yeah, 5 minutes. Okay, right. I'll go for 5 minutes. Then copyrights and related rights. You have to remember, copyrights is the rights of the lyricist, or the musician, or the author of a book, right? Because he is the person who has created it originally. The original work has been done by the original author, so therefore the copyright belongs to that original author. But uh, there are other rights also arising out of copyrights, very close to copyrights. That's called related rights. Because now in Sinhala we call it Asanna Himikam, or the neighboring rights. It's very close to copyright, but not copyright. But it's a right of a presenter, or the performer, or the musician, or the actor, right? So these are all known as performers, and that's called related rights. And you need to remember, when the work is done, they don't have to register like designs, patents, or trademarks. They just get the protection by way of publication. The moment it's published, and the moment it goes into the public through through a medium, then it starts getting protected automatically, and protection goes up to 50 years, right? So therefore, the moment a song is sung on the stage or in a channel or somewhere, then from there 50 years only the protection uh, goes on for the singer. But as for the lyricist or the musician, it goes on for the lifetime of the author, the creator, that is the lyricist or the musician, and 70 years thereafter. So you need to remember there are two different aspects here, copyright and related rights. And we have done a lot of work on this area. And even today in the morning, I was at National Library Services Board making a presentation, because today being the copyright day, tomorrow being the copyright day, 23rd, I did a presentation on this area only. So we have to do a lot of work on this area in order to get some information. Just for your knowledge, copyrights grant the rights to the original author. Uh, and then economic rights and moral rights. That is, economic rights means the rights of the author for the lifetime and 70 years thereafter. But moral rights means the right to get your identity published, that you are the creator, right? So this is why we say when a song is being aired on TV or broadcasting radio, they have to they have to display the name of the original creator, original lyricist, musician, and the singer, so that they are protecting the moral rights of the creators. So this is another aspect. So these are only few things, and when all these are enforceable and enforce rights enforceable, uh, now copyrights need not registered with us, but you get automatically. And also, if to be enforced, it can be a civil, criminal, and all any administrative action by intellectual property office. Uh, and we have a system called dispute resolution mechanism for copyright, where we look at the problem and we try to give a solution. So these things are for the enforcement. And I think we have come to the end. I have moved fast. So let me
Yeah,
answer
ma'am.
your questions.
I will
Yes.
draw you some of the questions inbox here. The first question is, what
Right.
is the procedure to file an international, in brackets US, patent after obtaining a national patent?
Yes. For the US patent application has to be filed through an agent, right? Once you file the application here within a year, you can file another application in the US through an agent because there are IP agents in the US and they will handle it. And thereafter, you can get the patent in the US. Otherwise, you can go for the PCT applications also. That is also within a year. If you file a PCT application, you can ask for the priority of this application in Sri Lanka, and you can indicate several countries under PCT application, not only US, but also other countries. And you can decide later whether you are filing an application on each and every country who are members under the Patent Cooperation Treaty, that is PCT. So this way, there are two ways, but definitely it's through an agent that you need to file in that particular country.
Okay, another question. If the patent is valid for 20 years, why we need to renew it every 2 years time?
Every year after the first 2 years, right? Because it's very simple. The government has given you a monopoly, the patent holder monopoly, to work against any other person using this patent, right? It's a license given by the government, and why not pay it back to the government? Because you are earning some money. It's assumed that once you get the patent, you can't be keeping it in the cupboard or the drawer, but you have to start working on commercializing. So you are earning some money, so pay back to the government. So it's simple, right? Because we do maintain here your patent, and if ever somebody, a third party, violates your rights, there comes a requirement, and if you go to courts, if you have not renewed it here, you are under threat, like not renewed, and you cannot ascertain, you cannot exert your rights because you have not renewed it. So this
Another
is
question.
a
Yes.
universal system. Yeah. Yeah.
Okay, renewing a patent, is there another application, and does it need to be done by the applicant or inventor? It means a renewing and patent. Yeah, applicant should be.
Yes,
be
yes.
done
Once
by
the patent is granted, ownership goes to the applicant, and it is the duty of the applicant to maintain the patent up to the end. So therefore, you need to file a simple application with the fees. Then we issue you a separate certificate as a renewal certificate. So we can see a lot of patents granted here. They don't come with the renewal, and sometimes if someone is interested in commercializing only, they come running here to get it renewed. So by that time, sometimes it has lapsed also. Maybe about 5-6 years have gone from the start. But still we do allow with the surcharge to pay the renewal fee and maintain it so that the validity can be maintained and the value of the patent can be given back to the owner of the patent.
Okay, another quick question.
Right.
After the filing of an application for a patent, is it possible to do a minor amendment on the same patent document during the evaluation time?
Yeah, of course. Yes, we are very liberal in that sense. We are very happy if someone can improve something and then come back and make it patentable by way of a small amendment, but not copying from another thing, but to add value, to add something to the existing one. But during this period, we allow you to do anything. Yes, of course.
And there is another
even
one
for international patents.
Yes. Okay.
Even for international patents, through PCT system are filed with us by the IP agents here in Sri Lanka, that is lawyers mostly. Even they take about say 2-3 years to bring in some amendments because they are waiting till the international patent is granted in some country, saying these claims were changed in that country and they granted the patent and wait till we get the document. So they ask for more time, so we will have. There's no problem.
Okay. Okay. Another one, I think one more last question. If they are the
Yeah.
If the
Yeah, no
author
problem.
are the same for publication and the patent, if the authors are same for publication and the patent, will it be a problem? Since patent drafting is late, the publication can happen earlier. It's a question. Yes.
Yes. It is a problem because we have seen that because patent drafting takes time and people tend to publish it faster so that they maybe for university purposes and their academic purposes they need to publish. But that's a big problem because even if it's the same person, there is a risk because uh, publishing makes it invalid to grant a patent. That's a bit of a tricky area where we in our act the provisions are same as in other countries. We are also getting held up because of that. This is why we say we cannot go beyond the limits in the act, provisions in the act. So therefore, it's safer before you publish it, you start drawing up the patent application and at least part of it, draw it, draft a few claims and file it here and continue with the rest of the amendments later. File the application and keep. Right? I think if they are genuine researchers, genuine inventors, and if they are so brainy enough to do a research and a development, drafting a patent will not be a problem because we are here to help people. It is our duty, it is our responsibility to help. So therefore, we invite you to come here and get our advice.
Okay, I think the last question. If we establish a method, a protocol in Sri Lanka for the first time, which was available in other countries, what is the method for protecting the right of the person who first introduced the said procedure to Sri Lanka?
Oh, well, I think I didn't get the point.
Yeah, the question I will repeat. If we establish a method or protocol in Sri Lanka for the first time, which was available in other countries,
Right.
what is the method for protecting the rights of the person who was introduced the said procedure to Sri Lanka?
Actually, what I understand from this is, I don't know whether I am right,
Yes.
but that person can correct me. Now, what I understand is a person is filing a patent application here for some method that has been patented in another country, right? International patent or whatever. This is available in the prior art. This means it's available in the prior art. And if he files it here, we will not be able to grant the patent. First is that to the particular person because it's already in the prior art. And if it is published, we will also see it when we are doing the evaluation process, right? Then the local person, the applicant, will not get any right, right? I don't know whether it is the one that you are asking the same.
I think so. Yes, it's not much clear.
And if we are granting here an international patent granted already for a certain product, and a local person copies it and files it here, it's a violation of rights. And if we grant it, international parties will file an action against the parties and also against our office for granting that patent.
Okay. One the small question, last one, I think. Can we accept that online application due to this COVID situation in the country?
Of course, yes. Now, up to March, for over 1 year, we have been accepting online applications actually, payments and also the scanned documents we were receiving. And then since March, we have opened up fully. And now we have stopped receiving online applications. And because it's kind of a duplicating of work here because issuing of receipts is a problem. So for the moment, we have stopped the online system, and now anyone who wants to file an application here can come to the office and file it. So not anymore.
Okay. Okay. Thank you, Madam Ranawaka,
Right.
the DG NIPO, elaborating in the important aspects of the inventions, patent IP rights, and over the invention actually. So we will, I think we have to going to finish this webinar. I think hopefully, I think good information has been shared, and thank you very much for participating and being involved with the actively with this webinar. And I think the token of appreciation must be handed over, Madam, within short period to your office. And I also must thank I also must thank all the steering committee members of ISF 2021. Giving hand to organize this webinar within very short period. And also we shall meet you all the ISF members with the important hot topics in near future. And always we, the ISF is happy to help all the ISF members. And thank you for participating this webinar. Thank you very much and have a good day. Thank you very much. Good night.
Yeah, thank you very much for organizing, and also thank you for following well without any disturbance. And I wish you good luck and wish you good day. Thank you.
Thank you, Madam. Thank you. See you.
Welcome.